Can a simple conversation or handshake really lead to a legally binding agreement? The answer might surprise you. Verbal contracts, while often overlooked, can indeed be enforceable in court. However, proving their existence and terms can be challenging. Verbal agreements, also known as oral contracts, are legally binding in many cases. They carry the same weight as written contracts, provided they meet certain criteria. These include an offer, acceptance of that offer, and consideration, which is typically an exchange of value between the parties. But how do you prove a verbal agreement in court when there's no paper trail? This is where creativity and diligence come into play. Courts look for supporting evidence such as witness testimony, correspondence like emails or text messages that reference the agreement and even the conduct of the parties involved. If one party has partially fulfilled the contract terms, such as delivering goods or services, this can demonstrate the existence of an agreement. Payment records and bank statements can also serve as powerful evidence. It's important to note that some types of contracts fall under the statute of frauds and typically require written documentation. These include contracts involving real estate, agreements that last longer than 1 year, and the sale of goods worth more than $500. If you find yourself in a situation where you need to sue over a verbal agreement, there are several steps to follow. First, gather all available evidence. This might include compiling witness statements, relevant correspondence, and financial records. Next, consider sending a formal demand letter to the other party, requesting they fulfill their contractual obligation. This step alone may resolve the issue without the need for litigation. If the dispute persists, you may need to file a lawsuit. In court, you'll need to demonstrate 3 key elements: that a valid contract existed, that the other party breached the contract, and that you suffered damages as a result. If successful, the court may order monetary compensation or require the breaching party to perform their obligation. However, enforcing verbal agreements comes with its own set of challenges. The lack of tangible proof can lead to he said, she said situations, making it difficult for courts to determine the truth. Additionally, state laws vary regarding the enforceability of verbal contracts, and statutes of limitations apply. Most states allow between 2 to 6 years to file a lawsuit for breach of an oral contract. In conclusion, while it is possible to sue someone over a verbal agreement, it's always advisable to document important agreements in writing whenever possible. This provides clearer evidence of the terms agreed upon and can save significant time, stress, and resources in the event of a dispute. Remember, in the world of contracts, clarity is key, whether spoken or written.